Can I take a photo of a famous trademark, the goods of a famous trademark, and put it on a shirt? Somebody asked me that. I'm going to spend the next 4 minutes answering that question. I'm Angela Langlotz, trademark and copyright attorney. I go live here on weekdays to discuss trademark and copyright issues. If you have trademark or copyright law questions, drop them into the comments below. I'll answer them just like I'm answering this one on a future live video. So somebody on YouTube, I'm going to tag him so he knows that I answered, sent me this question. He said, Angela, can I take a photo of Nike shoes, put it on a t-shirt, and sell the t-shirts? And the answer is no, absolutely not. Do not do this if the photo shows the Nike swoosh or the Nike word trademark. Why? Because those two things, the Nike swoosh symbol and the Nike word trademark, are both registered trademarks of Nike Corporation. And as the trademark owner, they have an absolute monopoly on the use of those two trademarks, together or individually, on clothing, shoes, and any other listed items or related goods in their trademark registration. So if you want to take a photograph of some Nike shoes, great, perfect. You can do that all you want. And you own the copyright on that photograph because you're the one that squeezed the shutter button, right? And that's fine. But the minute you print it on a t-shirt and start selling it, that is now trademark infringement because you don't have the right to do that. Nike has all of those rights. Now they can license out those rights to other people, but unless you have a license from the Nike Corporation, that is trademark infringement. The other issue too is that as a trademark owner, Nike also has protection against something called infringement by dilution. Nike is a famous mark. This means that as a famous mark, they get this extra protection from infringement by dilution, which means that nobody can put Nike on anything. Pencils, paper cups, mugs, anything without infringing Nike's trademark. Now, why is this? Why do famous marks get this extra level of protection? Well, it's because famous marks tend to expand their brand into a lot of different things. For example, Tiffany and Company. Tiffany's another famous mark. They make jewelry and other luxury goods, china, silverware. Now they're making handbags and sunglasses and things like that. They recently expanded into a restaurant. So now you can really have breakfast at Tiffany's restaurant in New York City, and it uses the Tiffany name and their iconic blue in the restaurant decor. So it is very common for famous brands to expand their footprint. It is also very common for famous brands to have merchandise deals with other manufacturers. So, you know, Nike could come out with a line of, I don't know, Nike theme parks. M&M's has done that. So it's very, very common for famous brands to expand. And if we allow infringers to chip away at the edges of their brand and infringe upon their brand and dilute their brand, then the famous mark holder won't be able to expand their brand footprint later if they decide to do that. It's also confusing because as consumers, we would look at whatever Nike branded thing and assume that it came from the Nike Corporation, even when it's not true. It's coming from some infringer. So we have to stop infringers from doing that because it is confusing to the consumers, and consumer confusion, the avoidance of consumer confusion, is the whole reason why we have trademarks in the first place. Ask me any questions, find me online. I'm at TrademarkDoctor.net. I'm also on YouTube, where there's a huge channel there, probably more than 500 videos at this point. It is found at video.trademarkdoctor.net/YouTube. I'm on Facebook at facebook.com/trademarkdoctor. And I'm on TikTok. Just go search Trademark Doctor.